All right, good morning or good afternoon. It's good morning for me. Good afternoon for Brad. This is Curt Marone.
And Brad Pinsky.
All right, and we are here for another edition of Fire Law Roundup. I am coming to you live from Phoenix, and Brad is in Syracuse. I'm assuming at your office.
Yep.
And boy, crazy couple of days here. But Brad, go ahead, kick us off. This is
Sure.
August 7th.
Yeah. So, okay, I'm going to pick up the first three cases. We have some really good cases. This is an interesting week, and I really look forward to the back and forth on some of these. The first one, which is just interesting because we have seen this a number of times where EMTs are stealing. So now the FDNY gets hint that an EMT is stealing from patients and arranges a sting to set them up. So the FDNY stages a person as a patient. They intentionally get the suspect dispatched to the call. They have marked bills of about $1,100 in the wallet. And when they transport the patient, not knowing it's not real, right? They transport the patient, and the patient / undercover investigator determines that about $600 or more is missing. And this person is now charged with a felony, grand larceny in the 4th degree, 2 misdemeanors, petty larceny, official misconduct. And I'm suspecting there will be more because remember, that's for this, right? So there could be the prior ones, which now they may be able to say, well, now we are convinced he was the one who was stealing. So, simple lesson, don't steal.
Yeah, no, absolutely. And but I think from a leadership perspective, I've had to deal with this. I know some of my clients have had to deal with this. And as I travel around, many fire departments have had to deal with this. And the way it happens is you're going along, you've had EMS, you never had a problem, and all of a sudden you get a report that money's missing. You say, well, maybe they are absent-minded, and in all the stress from the medical emergency that they have, and maybe they misplace it, or we write it off. Okay. Right. Well, no, it happens. I mean,
yeah. And it is.
Maybe you talk to the people, but whatever. Then another one, then another one, then another one. And I know the ones I've been involved in, it ends up in a spreadsheet, and you start looking at, okay, where's the common denominator?
Yeah.
And pretty soon, and I don't know, I can't say it's after 5, after 10, after 15, but at some point, the spreadsheet comes out, you look at and now you're confronted with something. Yeah. Do you, and I think one of the mistakes that many fire departments make is they call the accused in, and they try to interrogate them, and somebody's going to be doing something like this. Is not just going to roll over. We had the one that I was involved in. This is, kid comes from a hard criminal family. I mean, most of his relatives were at our ACI, and he's not going to roll over. And you've got to also assume that when you catch him, if you try to do it on your own, if the fire department tries to set up its own sting, that he's going to pull out every excuse in the book. Oh, I was taking it for safekeeping. I was afraid that he may lose it given his mental status. They're going to come up with all the excuses. So leave it to the professionals. Okay, you leave it to the pros, the police. In this case, it was their Department of Investigations, the New York City Department of Investigations, which probably handles more criminal cases than most police departments in the course of a day. And they were set up for it. They knew what they were doing. They had a plan. They executed it, and
that's what it is. So, but you're right. It happens all the time. Usually, elderly people, and we tend to write them off. Yet, knowing that, people who will prey on them, right? People prey on the victims who we're not going to believe anyway because, but I think you're right. And I think if you are an agency and you receive more than one, I think 2 is enough. You better start looking
you've got to investigate any. You have to investigate any, but it's hard.
Of course.
It's hard. Like you call the people in and they go, we don't know. I mean, we didn't do anything. That's, they're not going to just roll over on it. But after you get the second one and the third one. And then you got to start looking at the common denominators. And just by looking at it, you may get it to stop. You may. I'm not,
Right.
not an absolute, but by looking at, but if you just do, well, maybe it was this and maybe it was that. And sometimes we tend not to look hard at people who are high performers, who, when you need somebody, it's 2:00 in the morning, somebody just went out on an injury or sick. They're
They're our favorite person. We trust them.
And that's some of the challenges, but we got to be prepared for it. And in the cases I've been involved with, 100%, it's been drugs. 100%. Okay.
Yeah.
So it's another reason why we've got to really be watching things, because if they're stealing money, then they may be stealing other things as well, particularly to support their habit. So get them before it gets to a point where it's criminal, get them the help they need. Maybe we can get them turned around as a good employee, maybe not, but.
Right. Okay. Let's go to Lansing, Michigan. I love this case, or it's just a lawsuit. It's just filed. It's a continuing saga of things, but let me give the brief facts, because I really want to have a good in-depth conversation on this. So we have an African-American male firefighter. He has been terminated for what he claims, right? The reason he's giving us, I'm not sure whether I know is true or not, but he claims, remember, these are just allegations. We don't have any trial or discovery. But he claims he was fired for free speech, for posting the police chief's personal cell phone number on Facebook in 21. He claims that he's been subject to retaliation and to worse working conditions, and his medical leave is treated differently than others. But here's basically what happened to get him to here. So in August of 19, he attends a town hall meeting. And he keeps, when you read the complaint, he keeps making clear, as he should, as his attorney should, keeps trying to make clear, I was never in uniform, not part of my job duties, 100% acting as a private citizen. And we'll discuss Pickering for everybody in a moment, the case that obviously they're pegging this under. So he claims that I went there, spoke to the police chief, told him about a not-for-profit corporation I've been forming and all these good things I've been doing. And the police chief handed over his private cell phone number and said, hey, call me. And let's discuss your not-for-profit. And then over time in 2020, later, him and his wife create this podcast, which is on Facebook and other places. And they're talking about important issues, at least to what he would say is the African-American community. He said there were some things that the city did which upset him about, I didn't totally understand this, but posting a picture of a police dog who I think it was died in the line of duty. But he said, there was a
death of a young African-American. And he was unarmed, and I believe the police either shot him. He ended up dying in the same incident where the police dog died. And he was upset that the city was sort of portraying the dog as like a hero, and without mentioning the African-American youth who was killed in the incident. And he felt that ought to be at least discussed as well.
And look, in fairness to the non-biasness of our review here, that is clearly not a fire department issue. Maybe a city issue, but it's not a fire department issue. And he has every right in the world to express displeasure or almost anything with regard to speech about that. So the same thing happens again. He expresses his displeasure, but during all this time, which is significant, he's on medical leave. So I don't think he's a lieutenant, a captain, a chief. He's no rank that I can tell. And now he's on medical leave. So he's not even on duty when he's doing any of these things, which is not dispositive, but it's a very important factor. In any event, he then claims that he's being treated differently with regard to his medical leave. He's being treated differently than similarly situated Caucasian individuals. Through all of this, then he gets terminated in March 11th of 21 for what he alleges he was terminated for engaging in protected free speech and for posting the police chief's telephone number on the Facebook page. We don't yet know if there's an independent different reason for the termination. But if what he said was true, right, in my opinion, he meets the Pickering test, right? To keep it simple for the viewers, he is speaking as a private citizen because he was off duty, and speaking on behalf of the fire department is not his job description, presumably, and he was on medical leave, so it's certainly not his job duty. He makes a pretty good case for he's speaking as a private citizen, and he's certainly speaking on matters of public concern, right? The respect of African Americans, et cetera. So both of those are strong. However, they're going to have to establish that he was terminated for that reason and not for a different reason, and was being discriminated against for that reason and not a different reason. And look,
let me just take the contrary point, only because I've got a lot of friends up in Lansing and on both sides of this issue. So I don't want, and I'm trying to come down the middle. There's a question of fact, and it always comes up as to whether or not a firefighter who posts, was it actually as a private citizen? Was it in some way? And there's a lot of factual questions. Like, for example, he's got that Facebook page where he posted it. Does he make efforts to identify himself as a firefighter on that Facebook page? Did he post a lot of things about the fire department? Okay. Rank is very important here. And this is where I love my metaphor about the close play at second base, because just because the first runner on a certain team is out at second base doesn't mean everybody who slides into second base is going to be out. It's a close play. Point being, if you're a firefighter, that's one thing that goes into the account. If you're the fire chief, even though you're on medical leave, even though, you know, a lot of other things that you mentioned, okay, but you're the fire chief, that's a different slide into second base. Just because the firefighter is not not a government official, didn't post in his official capacity, you know, the fire chief. So rank, there's a lot of different factors. So I think based on what I see, I agree with you, but I think there's that close call. And then don't forget the third step, which is, I don't think there should be a third step, but they have that third step, which is where the court gets to balance the firefighter's right to say it versus the fire department's right to shut them up. And you can't predict that one. Yeah. You can't. I mean, there's just, you know, it allows a judge, our good friend Chip Comstock says it's the judicial smell test. Okay. Yeah. That if a judge agrees with you, that they'll use the balancing test to rule in your favor. And if they disagree with you, they'll go against you. The Supreme Court really ought to take a hard look at that balancing point.
Agreed. But look, and all of this assumes that any of it's true, right? We don't know yet what is true. We just have allegations. And I suspect the first thing you're going to see is he was not terminated for free speech. I'm making this up, right? But he didn't come back when he was required to, or he falsified his reasons for leave. I mean, there's a million other things that are going to come into play right now that the suit's been filed. So you and I will inevitably be speaking about this again when more happens. I'm predicting there'll be maybe a motion to dismiss, but if not, we'll see.
Yeah. Well, he already won $1 million for race discrimination on a prior claim.
Right.
And so, and that case was pending, and I'm surprised there's not a retaliation aspect to this related to his prior suit, because that's not that factually there was retaliation, but I think from an attorney's perspective, we're going to put it in there because he's suing the city, and then all of a sudden he gets fired. And that's, you know, it looks like there might be a time-wise, there might be a connection there, but
and that could provide a good impetus for support retaliation claim, which, right, again, it's all got to play out.
Yeah.
Okay, so now we're going to go to Cobb County. Where the heck is Cobb County?
Georgia.
Oh, okay, good.
Outside of Atlanta. Yeah.
Won't go to Fulton County. They're indicting Trump at the moment, but we'll go to Cobb County. So Cobb County, this is about, before I give you the very brief facts, this is about a lesson in PR as far as I'm concerned. Fire chief, all the kudos in the world to you, because we have 7 or so firefighters who go into a proctored exam, I think for operating fire apparatus. and it's a course, and the proctor leaves the room, and 6 or 7 or so individuals then collaborate on some answers, right? I.e. may have cheated or, improperly dealt with it. In any event, the proctor comes back in the room. Somehow this gets discovered. And I'm guessing there were more than 7 people in the room, and maybe one of the others said something about it, but I don't know. In any event, what I take from this is not that people cheated. What I take, and I like what you did with the blog, is you focus on what the fire chief said. And the fire chief said this, right? I'll kind of read from it. I believe that some really good people used some poor judgment that day. They were all very forthcoming. They were all very honest of what occurred, and quite frankly, they owned it. It's standard practice to review the test, right? But once it's handed out, nobody should be speaking. And then he goes in and says, look, the proctor shouldn't leave. The students shouldn't leave until everyone's done. They should all stay there. And I agree. And I, I've been part of it where people are like, what the heck does number 2 mean? What the heck does number 3 mean? People are just expressing frustration, and maybe someone turns around and says, oh yeah, it's A, or what, who knows what happened.
Well, you know what, you've probably seen the same thing, and maybe you haven't thought about it this way, but I think there's some tests that we have to take that are nothing more than a check the box activity. Okay. You come out with a new policy, and maybe it's a social media policy. There's a lot of different aspects to it. You go to a 2-hour class on the new social media policy, and then they give you a 10 question quiz on it. That's a check the box activity. That's not, there's nothing sort of in the balance there. It's just a document that you understood the material. The instructor can read that. Okay. Sometimes with the annual CPR stuff that we've got to do, it just drives you crazy. And then you're supposed to annually certify for your SCBA and annually certify for this. So we go through a lot of check the box stuff. And then you have a credentialing exam. Okay. It's a state exam. And it's hard sometimes to draw that line for firefighters, I think. And that, maybe it's a leadership issue here that we got to, look, this is a real exam. It's not a check the box exam, right, like a lot of the things that you have to do, and make it clear and make it clear. Because I think when folks realize it, they're not going to pull a stunt like this on a serious exam. Okay. But where the lines are murky, you have this kind of thing happen. So
agreed. And we're not excusing it, but I agree. It's happens all the time. Sexual harassment exams, bloodborne pathogen. We're like just so sick of it. We don't take it seriously, but
every year. Yeah.
Well, federal government, right? Okay. Next 2 are yours.
Hey, let's talk about
these
New York
2.
State. Let's talk about your New York State annual sexual harassment training. Okay. Right. And I don't know if there's a required exam for that, a required quiz,
You're supposed to have questions and answers. They can be verbal or written. And obviously we're not, the problem with repeated check the box exams is that's the attitude you get. You can only hear things so many times. On the other hand, if someone like I do sexual harassment very differently, not to get off on this topic at all, but I do it. I'm going to scare the hell out of you because what I say is you better watch Curt and I, because 70% of our discussions are about what's going to get you in trouble. And obviously somebody's not paying attention. So in any event, but we
wouldn't have anything to talk about. We'd have to talk about stuff like building construction, firefighter safety, incident command, tactics.
God forbid we focus on the mission. So true. Okay. Well, stop harassing, stop cheating, stop stealing. And I think those are our 3 lessons so far. Okay. You've got the next one. Which I love this case.
A case we've covered before. It's out of Lincoln, Nebraska, and I know I've got some friends out there. And this is a tough one. And it's hard to tell from a couple of thousand miles away what's going on, but it's a kind of a familiar fact pattern. And again, to me, the legal world when it comes to fire service HR cases is going in one of 2 directions. Okay. We either have people who are mistreating, supervisors often or colleagues mistreating employees, and they push an employee to the point where they have to file a lawsuit. Or we've got an employee with an issue, And that issue causes them to perceive things that are pretty much routine. And as a result, they're perceiving these things in a way that feels offensive to them. And they're creating a narrative where they're the victim of what's going on. And this is a perfect example. I have no idea which of those two, but I'm pretty sure it's one or the other is going on in this case. But we have a female firefighter who's claiming, she's filed a lawsuit claiming that she's being sexually harassed and claiming retaliation. And so she had that lawsuit going initially. After the suit was filed, she claims that, and she was an acting captain at the time this particular incident happened, she claims that a captain of a different company abandoned her crew in the building.
If I think it was truck company or
furious, yeah.
I
I don't know if you're the captain of one company. I don't know how the captain of a different company abandons you in the building unless you were, put together as a task group, task force, division or group or whatever it is. But
yeah, I mean, think of it like don't get ahead of the hand line, right? The Black Sunday type, thing where, okay, engine crew supports the truck crew. Maybe one wasn't supporting the other.
Right. But if you're in charge of ladder 3 and I'm in charge of ladder 6, and you go in the building, you're ladder 3, I'm ladder 6. I might have a different assignment. I'm not abandoning you but I don't, we don't know all the things. But the bottom line is she felt that the captain abandoned her and her crew, possibly in retaliation for her earlier claims against, I believe, the same captain about gender discrimination and so on. So bottom line is she sought an injunction. So she had the lawsuit filed. She sought an injunction to separate her from this captain and for the department to discipline him and so on. And the court said, no, we're not going to go there. Okay. So now the case is proceeding and the city filed a motion for summary judgment. And so the issue is they're looking at the entire case now and determining whether or not there was enough there for the case to move forward. And for the most part, you can read the allegations in there. For the most part, the court went issue by issue. Some things they threw out, some things they said there's enough here.
Barely enough.
Barely enough for her to get to trial. So that case is going to be proceeding to trial. We'll be following it to the best that we can.
And it's important to know what you highlighted, which is the judge really said a jury's really probably most likely not going to find in her favor, but it's possible. So I'm not going to supplement my jury or my judgment for the juries. But he really made clear you don't have a great chance. To me, that happens one of two reasons. One, he really believes you don't have a great chance. And that's probably true because he doesn't want to put that in writing, right? But two, it also may be to get the parties to come together on a settlement, bring you back to center.
Yeah. And I think that's, there's, you see things, so it's like a baseball game. You see things happen and you may not understand why. You see the coach take a pitcher out and saying, why is he taking him out? But you don't know, maybe the guy's got some elbow issues or shoulder issues. They're trying to protect him. And so you don't know. And again, we don't know what's going on in the background here, but it did seem like the judge certainly was not encouraging her and sending positive vibes to her in terms of her claim. Now, that doesn't mean her claims are bogus. I'm not saying that she's the problem, but typically what happens is usually there's either somebody who's on one side that's creating some problems, and then you have a victim that now is suing because they've been victimized by that person, or we have a victim who, by objective reality, really doesn't have much to go on. And, which of the two, that's what if I go for a PhD, Brad, that is what I want to study. What is the percentage of time that we see a perpetrator really being the problem, and which of it do we see the victim who's sort of misperceiving reality, according to everyone else, misperceiving reality? I think that'd be a fascinating subject. So probably,
today
I'll probably go for that when I'm about 75. I got too much to do right now. But
an older PhD, why not? So, but I will tell you, today I got a letter from an attorney threatening one of my clients, the fire department and his chief, for defaming this person because he accused her of stealing. Yet he does an investigation, and he's got written document. He's got a written basis of things she wrote that make it look like she, in fact, did attempt to divert funds. And right. And so I wrote back, because I've got her saying, no, pay a check back to me, not the fire department. She literally is saying to somebody, no, I'll take that check. Don't send it to the fire department, when she was getting when they were getting a refund. So she diverts this. So I wrote to the attorney and said, maybe you haven't had the full benefit of all the facts from your clients. And I got to tell you, I probably copied the same paragraph I do out of other things. It's the same thing. It's always people making claims. So the problem with your PhD is many of these things, when the attorneys investigate on one side and respond back to the accusing attorneys and saying, well, maybe you didn't know all this, right? I think you would have bad statistics because of all the attorneys, hopefully like me and ourselves, who would say, well, why don't you consider the actual facts, right? And we could prove those actual facts. And then it goes away. And how many times does this happen? I sent you a letter, the other week about a big sexual harassment case, right? And it took me probably 15 pages to respond to all the allegations. But once you look at the facts, so I think it's too easy for attorneys to believe whoever walks through the front door first, right? Yeah. If you're the accuser or the accused, attorneys tend to believe whoever walks through the front door first. But that's where it should stop, because at that point, before you write a letter accusing somebody or file a lawsuit, if you've got time to hold off, why don't you do an investigation? And that's what we don't see a lot. We just don't see the attorneys doing a good investigation as they should. And that's why we see, I'm not saying this lawsuit, that's why we see a lot of these things happen.
Right. And even if I come up with a statistic that it's, 70% one, 30%, 60%, 40%, when it comes to an individual case, that's not really a lot of help on that individual case, Right. So the statistic, but the curiosity that I have over this issue is, and I think by looking at it, we can look at some parameters that can help us better understand what to look for in these cases. But by the way, and for the folks who aren't attorneys that are listening, before an attorney files a lawsuit, they're under an obligation to do exactly what Brad said, to do that diligent research to make sure that they're going to be able to prove the case. Not necessarily when you send that demand letter, but certainly when you sign the petition or sign the complaint that's going to go to court, you have that obligation to, make sure that the information is verified. So, or verifiable. So, all right. Well, let's get into the last case here. And this is an appellate decision by the Sixth Circuit. Brad, do you remember this case at all from, because
how could I forget a dead body waking up alive in the morgue? Right.
I don't know where the, I don't know where the mistake was made here, but we have firefighters that respond to or EMS personnel. They're called firefighters and they're called EMS personnel. So the employees of the Southfield Fire Department.
And they're definitely paramedics.
Yeah. And they respond. Now, the woman had, was it cerebral palsy?
Yeah, I think it was CP.
CP, and she was in respiratory distress. They apparently worked her for 30 minutes. Many states have a protocol that says that if you work them and the patient is still in a systole, that CPR can be stopped. They contacted medical control. Medical control said, stop.
Yeah, except they had stopped CPR 5 minutes prior, which they probably forgot to say.
Well, the bottom line is, so they stop, and then apparently people keep telling them, police officers and others keep saying, she's still breathing. Which I don't understand how she could be an asystole on your equipment.
Well, wait a minute, but she wasn't. That was the point. So the monitor is still showing some electrical activity. What happens when you administer epinephrine, which you often do at least twice in a cardiac arrest, the epinephrine is a chemical agitator. It agitates the heart because defibrillation alone may not work. So you agitate the heart so it can get into a shockable rhythm. That was my very layperson 30 years of EMS explanation. Paramedics, please excuse me. But they're saying that, well, we're getting electrical activity, but they kept dismissing it because they said, well, it's probably, it doesn't say this in the papers, but it's epinephrine. That's my bet, is it's epinephrine agitating the heart, and that does create some electrical activity. So they wrote it off without verifying that it's electrical activity right up until, she's takes a breath.
Well, they put her in, not them, the fire department calls it, they come back, they check her a couple of times. But bottom line is they leave the scene, they get a funeral parlor comes in, put her in the body bag, off to the funeral home.
My worst nightmare.
The embalmers unzip the bag and she's looking at them breathing. So then they call the fire department, they take her in, they work her, and apparently she lives for, is it 6 months or 6 weeks?
Yeah, she's on life support, but
yeah, she's on life support, and then she ends up dying. So the bottom line is the case was dismissed against the fire department. Okay, so they sued the fire department, the case was dismissed, it was appealed up to the 6th Circuit, and you can read sort of the conclusions of the 6th Circuit, but the 6th Circuit, again, this is an important distinction now. Maybe I should have
civil versus negligence,
right? Yeah, the family did not allege negligence, at least in this part of the case. Now they may allege negligence as a state law claim, but
no, I think they did, and then the judge dismissed that part.
I don't think so. I think they allege negligence, okay, which I think is strong here. If they were not government employees,
right,
slam dunk, you've got a case for negligence. Okay. Slam dunk, I don't think there's any question, okay? But government employees have a number of certain protections, including tort immunity. We may have some statutory immunity. There's the public duty doctrine. There's a bunch of defenses that government has that private sector folks may not have. So there's a number of tort defenses. So what attorneys in a case like this will do is they'll allege the negligence, which is based on state law, but they'll also allege federal civil rights violation when it's government. So they allege that her due process rights, the 14th Amendment says you have the right to life. You shall not have life, liberty, or property taken away from you without due process. And the allegation here is that she had her life taken away from her without due process. So sort of a convoluted legal theory underlying this, but they sued under the 14th Amendment due process clause. And so in analyzing this, and what concerns me is that folks can read this and assume that it's okay for firefighters to do this. And that's not what the court is saying. The court said, both the trial court and the appellate court said, is that it's not a civil rights violation. Okay, so if the firefighters did something wrong, which arguably they did a couple of things wrong, okay? But if the firefighters did something wrong, sue them for negligence. But this is not a civil rights issue, okay? You can't squeeze this into the very narrow civil rights aspect of someone's death.
And I think the reason, because a lot of people might jump on the attorneys saying, well, why did you go after something that was very, I say, obviously, there's a number of other cases, the court even cites to one where this shows this is an uphill battle. Why didn't they go for the low hanging fruit? Well, and let's talk about it. One of the reasons is because the standard wouldn't be mere negligence. You failed to act as an ordinary EMT. The standard may be you failed to attempt to act like an ordinary EMT. And that is a much harder burden for a plaintiff to overcome, to show like you didn't even attempt it, because they worked her for a half an hour. And while they made mistakes, they clearly administered drugs, did CPR, they worked her for a half an hour to no avail. So it's not like they didn't attempt to be careful. Now, then you get into the hardest, which is proximate cause. She is down for 25 minutes, 30 minutes, and to show that she would have survived and had a quality of life or anything like that is going to be very hard to prove proximate cause. And then damages is even tougher. And the only reason I won't say much more on that is because I don't know how advanced her CP was. I don't know if she has any cognitive function or not. right? But if she has no cognitive function, no pain or, sensation or whatever, then there's almost no damages regardless. She went from one difficult state to another. Now, she may not be severe CP, but there are a number of possible reasons why a plaintiff's attorney went this route, as opposed to why not just sue for negligence? Because that also, when you've worked somebody in presumably good faith for 25, 30 minutes and you're not getting any response on scene, you probably have fulfilled good faith, or you've probably at least been attempting to act carefully, even though you discontinued care before transport, right? Would that have resulted in a successful save? I don't know. Maybe it would have, because ultimately she came back. So I don't know, but there are a number of other reasons why the attorneys might not have done that. I'm not going to jump all over them in this case.
No, and I think I would have done the same thing in a situation like that, where I decided I was going to move forward with it, and I'm not sure I would have moved forward. But I have a sweet spot in my heart for what folks that were on the scene there had to go through. But here we go. There's one comment in here, and I'll just read it. It says, qualified immunity shields government officials from monetary damages as long as their actions did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. That is an accurate statement of the law if they had limited it to due process allegations, violations of someone's due process right. It is not an accurate statement of the law with regard to negligence. And so, and the reason I say that is I saw a lot of media coverage of this. The normal media outlets that cover these types of things are sort of glossing over that and basically saying, as long as you didn't violate clearly established statutory constitutional rights, you can't be held liable. That is not true. You can't be held liable for a civil rights violation, but you certainly can be held liable under a negligence theory, assuming that they can, get over the hurdles that they have, sovereign immunity, public duty doctrine, and so on and so forth.
Right. Right. I was going to say, other than waking up with snakes around me, waking up in a body bag or a coffin would definitely be my top. So if you're one of the EMTs who's treating me and I'm in arrest, just let me go. I'm good. I'm good. So that's it for today. That was great cases. I love these. That was great cases.
That was a good week. And please, if you haven't already clicked like and subscribe, please do. We need the support. And do a little binge watching. We still need about another 250 hours in order to get up to, and it's kind of like we're losing, it's kind of like over a 1 year period. I think we've got to have, I think it's 4,000 hours of viewing hours over the last 52 weeks. So we lose a little bit off. And so every week we got to kind of keep increasing the number and increasing the number. So if you could do a little binge watching for us, we'd appreciate it. And please let your friends know. And, hopefully we'll see you again on another edition of Fire Law